Welcome everyone. Before we begin, I'd like to acknowledge the traditional owners of the land on where we're airing from live today. That's 44 Herschel Street, Brisbane City, at our Legal Aid office. And I want to pay our respect to elders past, present and emerging. Before I introduce ourselves and everything, I just want to quickly show our disclaimer slide that this information is for community legal education purposes only. Okay, so welcome everyone. My name is Ellen Limerick. I'm the Community Legal Education Officer here at Legal Aid. And with me today, I have the lovely Andrea, who is a Senior NDIS Appeals Lawyer at Legal Aid. So we're very lucky to have her knowledge today, and she's going to share with you some of her insights and learnings in this area of law, which can be very complex. So we're in for a very interesting webinar today, I think. And as I know, a lot of you may not have come to a Legal Aid webinar before, I'm going to go through some housekeeping. So this webinar is being recorded and technical help is available on that number on the screen if you have any issues on your end. And if you need to search for any of our future webinars or any webinar information, there's information on the Legal Aid website on our information for community workers and carers page. Now, if you'd like to download the PowerPoint slides from today, it's in the right-hand sidebar on your screen. So you can click Handouts to open the Handout section and click the link to download it. And if you've got any questions throughout the webinar, please let us know and submit your questions in the panel on the right. So we'll aim to have a 40-minute presentation and then we'll leave 20 minutes for the Q&A at the end. Okay, now I'd like to start off with a poll. So, oops. Oh, please excuse me. Okay, so I'm going to launch our first poll now to see where you work. All right. So please have a vote. Southeast Queensland, Far North Queensland, Regional Queensland, or outside of Queensland. Okay, I'll give you a couple of moments to get your responses. And then I'm going to close off the poll in a couple of seconds. I'll just wait for a few more votes. Okay, I'm going to close off that poll now. Thanks everyone for voting. And I'm going to share those results with you on the screen. So now you should be able to see the poll results. So as you can see, 58% of you are from Southeast Queensland. We've got 21% Far North Queensland, 15% Regional Queensland, and 6% of you are in another state. Well, welcome everyone. That's great, and it's great to have so many people from the regions with us today. Okay. All right, so I'm going to launch another poll. And that's which option best describes the field you are in. So are you a community worker? Are you a government agency rep, NDIS participant or family or friends of an NDIS participant? Are you a legal service provider, or do you not fit into any of those categories? In which case, I'm very sorry. I'll give you a couple of moments to enter in those polls. Okay, I'm just going to close off that poll now, and let's get the results up on the screen so everyone can see. Okay, that's great. So 45% of you are community or health support workers, 25% government agency representatives, 1% NDIS participants or family or friends, 8% legal service, and 21% other. Great. Okay. All right, I've got one more poll, and this will be really great for Andrea to know, so she can know where to pitch this presentation at to see how much you already know about the NDIS. So I'm going to launch a poll right now. So please answer, how much do you know about the NDIS? Do you know a lot? Do you know a little bit? Or no knowledge at all?
Yeah, this will help me to target, I suppose, the level.
Yeah.
As I suspected, though.
Yes. All right, I'm going to close off that poll now that most of you have voted and share it with you. Okay, so just a few of you know a lot about it. Most of you have good or limited knowledge of the NDIS. Okay, and some of you don't know much about it. All right, is that what you?
Yeah, that's what I expected. Thank you, everyone.
Thanks, everyone. Okay, we'll get into the presentation now. I'm going to hand it over to Andrea to go through what we'll learn today. And then at the end, we'll have some questions. So please pop in your questions as we go, but we probably won't answer them till the end. Okay, thanks.
Hi, everyone. I've been working in this area for almost a year now, providing advice and casework assistance to participants, helping them to overcome what I see as the hurdles, two key hurdles. The first being getting access to the NDIS, and the second getting the supports that they need to live an ordinary life. My overarching tip today that I will try to repeat as we go through is for participants and those people working with them or helping them is to swap their perspectives. So as the perspective of the participant, it can be really overwhelming and burdensome in terms of the evidence that they need to present to the NDIA to overcome these hurdles. Swapping the perspective and looking at things from an NDIA representative can help, because the participants and their family and friends, whoever's helping them, can see you know, what the law is and what boxes need to be ticked in order to get through those hurdles or get over them. We'll cover those things. That will be the bulk of the presentation. I'll cover off on how legal aid can help at the end. I'm very pleased to receive questions, you know, at this presentation at the end, and also afterwards referrals of clients for advice or minor assistance, or perhaps full representation as well. And anything else you want to know, by all means, please ask. I'll do my best to answer the questions that you present, and if I don't know the answers, I can always speak with colleagues or let you know that you need to go somewhere else to get those answers. That's about it. I'll also quiz you at the end, so I hope you all will pay attention. I'll do a little run through of a scenario at the end, and get your input on those answers as well. So hopefully that will consolidate.
So there's a test, so listen up.
There's a test.
Don't check your emails at the same time as this presentation. You'll get left behind.
Yeah. Okay. So the NDIS, most of you would know, stands for the National Disability Insurance Scheme. It's a new way, basically, for people with disability to get the help they need. For a lot of people, they've never received help before and now they're getting it, which is great. But for most people I deal with, they were getting help before through state disability service systems, and now actually they come across more hurdles with the NDIS, and they're finding it actually not necessarily a better way for them to get the help they need. It aims to build participants' independence, increase their participation in the community, and the words choice and control are often used to describe what the NDIS can offer, because instead of people getting packaged funding, I suppose, they have the choice and control to choose which service providers they engage to get the help that they need. I've mentioned already the NDIA, that stands for the National Disability Insurance Agency, and so within that agency there are planners, there are delegates of the CEO who are the decision makers, there are in-house lawyers, there are also external players, local area coordinators, service providers, some of you are those service providers, and disability advocates as well, and I hope some disability advocates are tuned in today. So I'm still learning about who's who, and it can be confusing because some of the external people, I was saying to Ellen earlier, have NDIS emails, so you don't actually know where they work, and we're forever getting updates about who best to contact in the event of some difficulty. There's relatively high staff turnover as well, so the who does change, but they're the basics there on that slide for you. Okay, so this is just the NDIS journey, we've called it. What happens? Someone lodges an access request. Now, if you want to get access to the NDIS, you need to first call. You can't just fill out a form, unfortunately, that's not available on the web. They need to then decide, yes, okay, you'd likely qualify, and send you a form. This is a tip right at the beginning in relation to overcoming the access hurdle, is if anyone calls and they're not provided with the relevant paperwork they need to complete to get access, they need to go to a disability advocate or call Legal Aid, because that's a problem in itself, is that someone is picking up the phone, is making a decision they're not really empowered to make right at the beginning. Now,
I'm sorry, I've just heard that you aren't able to see the PowerPoint slides. So what I recommend to people is to download the handout in the right-hand bar so you can see the slides as we go along. I'm not too sure why. Hold on a minute. Okay, let me see. Hopefully you can see our slides now. Okay, great. Sorry about that, guys. So you just missed our what and who slide.
Yeah.
So that was the slide that you missed. And now you should be able to see the slides. Okay, so you don't need to download the slides just yet. If you can't download them for some reason, I'll send the slides after the presentation today. But you should be able to view them on your screen now. Sorry about that, everyone.
You haven't missed a lot.
No, you haven't missed a lot. There wasn't much on there. Okay, no. So we're up to this one now.
Yeah, so this is just, I'm just talking about the NDIS journey. Someone requests access. Once they get access, they get over that hurdle. We'll talk in more detail about this. This is just an overview. There's a planning meeting. At that planning meeting, a planner prepares, or after the planning meeting, they prepare a draft plan based on the participant and their family, explaining their needs and what help they need. That draft plan is approved or not approved by a delegate of the CEO within the NDIA. So it's not the planner making the decision, it's another person, and that can be confusing for some, so it's important to distinguish those two roles. Then a person gets their NDIS plan, they use that plan typically for a 12-month period, funds are provided. They're looking at ways to make things more efficient and perhaps lengthen the life of plans to perhaps 2 years or more in appropriate cases, so there won't be a need for a review every year. So through that plan period, the person spends the funds that are allocated for supports, and then there's a scheduled annual review. So that's an overview of the life of a plan. Then through the scheduled review, another planning meeting occurs, and a person may need different supports. Their circumstances may have changed, or they may just say, no, look, this is all the same and this is what I need still. But as I will explain, they'll need evidence all the way along to substantiate what they're asking for, that's something that the NDIS should pay for. Okay. So key challenge, as I mentioned, evidence heavy. So really, it's really burdensome for people to provide the evidence to the NDIA in the first place, to get access, and in the second place, to get the supports approved, the funding that they need for the help that they need throughout the life of their plan. I can give a simple example of, for example, a person born without legs. From their perspective, they need help from the NDIS. They'll need some specialist equipment, some wheelchairs, some prosthetic legs, maybe a ramp in their home. But from the NDIA's perspective, they need to be able to tick the criteria in relation to that person needing access in the first place, and then that the supports are reasonable and necessary and ought to be funded by the NDIA. So even though this person says, hey, look at me, I've got no legs, I need to be a participant in the NDIS, that's not enough. They will need a letter from a doctor saying, yes, they were born with no legs. They'll need letters from occupational therapists saying, yes, they're impacted by the fact that they have no legs. So it's often evidence required is stating the obvious, or demonstrating.
Sounds crazy.
Demonstrating obvious, but that's what they need to be able to have, on their file and in their system. They need that information. So I've found personally, and my colleagues who work in this area as well, that when we're helping people, it's mostly about gathering evidence and helping them pinpoint what is going to help their case and help them overcome those hurdles. So statements about the impact on themselves, kind of a diary almost, or a day in the life of, to paint the picture for the NDIA about the difficulties they're facing. Reports, obviously, from medical practitioners, GPs, OTs, other therapists, psychologists. The NDIA were issuing requests for summons as a matter of course. If they do that now, I'd recommend you question that, because that's really burdensome on all the medical practitioners or the hospitals who are required to respond to the summons request and provide all the notes for a person for a 10-year period or whatever it is. So if specific questions can be answered in reports, that's a better way to go. I've included a link to this case, Maisie, and in that case, the tribunal said that, look, if a person needs to gather evidence of a particular support they want, and they've done that, that should be sufficient. If the NDIA are suggesting, maybe they don't need such a fancy wheelchair or such, a certain type of prosthetic legs, that's really for the NDIA, then it's incumbent, that tribunal use that word, on the NDIA to get evidence of those lesser expensive supports. It shouldn't be the participant's burden. And they often, that's kind of just an example of how burdensome it is. It's, you've got to provide evidence about the support that you want, and also provide evidence that the lesser expensive supports aren't going to meet your needs. So I've mentioned on this slide, my tip is to organise your evidence, and there's some tables that you can download.
In the handout section on the sidebar, you can download the tables now, or after the webinar, I'll also send you an email with copies, with attachments of the tables.
So they're pretty basic, the concept of these tables, but basically we've gone through the law, all the relevant criteria and the rules that expand upon those criteria in a table format. So on the left-hand column, there's the criteria basically, and then there's right-hand columns for clients, participants or their families, or advocates to complete, to see, okay, against this criteria, what evidence do I have to support the fact that I meet that criteria? They're a pretty basic tool, but we find that it's a very helpful basic tool. So other challenges are that the NDIS is still new-ish. They try to rely on that as a bit of an excuse that, that there's still room for improvement. They're not so new anymore, but they're still evolving. So there's inconsistency in service delivery from different offices that we see. The website, you know, good luck finding the internal review request form. It took me about 15 minutes. But I know where it is now, and I can share that if anyone needs to find it. Internal review decision-making processes are really problematic. So when someone does ask for a review of a decision, I provided advice to a client on Tuesday who's been waiting 10 months for that review to be done. And now the scheduled 12-month review is due anyway. So that can be really devastating for a number of people who are desperate to get a decision that will change the help that they're getting. It's evolving in terms of staffing. I mentioned before, there's an early resolution team that's been established, and there are lots of other teams with lots of different names that are trying to, you know, make improvements in the way that the NDIA delivers its services. So that's also a challenge we find as well. So the law, it's a little dry, but it's all relevant. So there's the Act. Under the Act, there are a number of different rules. These are the key ones that I've listed here. So there's rules for becoming a participant, and then there's rules for supports for participants. So they're the two kind of key hurdles that I mentioned at the beginning, but I'll expand upon during this presentation. Operational guidelines. Anything in light blue is kind of my take on it. So my take on the operational guidelines is they're not as important as the law, and that's what the law says as well, is that the law and the rules will trump anything in the guidelines, particularly as the NDIA guidelines. They are just that, they're their own guidelines for their staff, but also participants to follow its policy. So in the event of any inconsistency between the law and the policy, the law wins out. The guidelines aren't always kept up to date as well. So there are some things that are wrong in the guidelines that haven't yet been corrected by the NDIA. And so case law, because this area of law is relatively new or comparatively new, there's only been 2 federal court decisions. Another one is pending at the moment. And fewer than 100, the last time I checked, there are about maybe 85 tribunal decisions that have been reported. There's not a lot of published decisions because lots of these cases, every case I have run so far has settled, and there's actually been no hearing and no published decision, which I think is a bit of a shame, because there would be some good precedents that would be set if they ran to hearing. But obviously in the interests of the person who wants the help, they can get the help. Without a hearing, that's a benefit, you know, that's a good outcome for them. The federal court decisions, I can just name them. One is Mulligan and the National Disability Insurance Agency, and the other was McGarrigle. One was in 2015, one was in 2017. We're due to get another published decision in 2019. So maybe we're going to see a decision every 2 years. It's not a lot of case law out there.
So there's some light reading for you guys if you want to read some case law.
But yeah, most cases do settle, so there's not the case law out there that we can rely on as much as, you know, the other areas of law. Okay, so the 2 hurdles, getting access to the NDIS and also then getting the help you need, they are reviewable decisions. So people do have review rights. So if you're not happy with a decision by the National Disability Insurance Agency, depending on the nature of that decision, you can request a review. The law says the review must be made within 3 months and must be specific. The more specific you can be at pointing out what decision you're unhappy with and what type of review you want, the more likely the NDIA will undertake the internal review process in the right way. There's been quite a bit of confusion with internal reviews and how they are responded to. Then if a person's not happy with the outcome of the internal review that's done by the NDIA, they can go externally to the Administrative Appeals Tribunal, and that's really the area of work. You know, that's my field. That's what I do to help people. So once they've got an internal review decision, I help with the external reviews in the AAT. And the time frame there is that a request for an external review must be lodged within 28 days. So I've said that in relation to the internal review requests, be specific. We have seen instances where a participant has asked for a review only to be referred to the complaints department. And then months pass and then they follow up and say, where's my review at? And they say, we don't have any record of you asking for a review. And then the time limit, the 3 months, has passed and then they've lost that right. But with much intervention, for example, from Legal Aid, maybe they can get that right back. If it can be found and evidenced that the NDIA has done the wrong thing in response to that person's request for an internal review. So being specific is helpful. So we've just got a little kind of infographic here, review life cycles. So an original decision is made. Section 99 of the NDIS Act is a little table and it lists all the types of decisions that are reviewable. The 2 key ones you probably need to worry about and be interested in are the review of the decision to refuse access to the NDIS and review of a decision to approve a statement of support. So that's in a person's plan. The statement of supports will set out what the person gets funded within a year or 2-year period, and they may not be happy with that final approved plan. And often it can be in a meeting with a planner, the planner says, yes, we'll put all this into your draft plan, and then it doesn't all get approved. So if it's not approved, that decision to not approve it is reviewable. Firstly, an internal review, and then external review in the AAT. We've got a little caution jurisdiction sign here. So jurisdiction just means power. Whether the AAT has power to proceed to look at a decision of the NDIA depends on what the NDIA has done in response to the internal review request. So I've put a little note here that there may be a failure to do anything. For example, the client that's still waiting 10 months on for a review, she's got no right to go to the AAT. There's no time limit, unfortunately, on how long the NDIA must respond to an internal review request. So at the moment, I think the law says as soon as reasonably practicable. I think 10 months is probably not as soon as reasonably practicable. That's a bad example, but you know, it's not uncommon for it to be at least a good few months before the NDIA completes their internal review. And then also they may mischaracterise the request in the first place, consider it to be a different kind of request for review or a complaint or something else, so it never can progress then to the AAT. And so then the tribunal process, generally the tribunal member will stand in the shoes of the decision maker in the NDIA and again look at the criteria in front of them in terms of what decision they can make and the evidence against that criteria that we'll go into in more detail soon. Okay. So the reviewable decisions, as I mentioned, there's 2. On the plus side, if a person doesn't overcome these hurdles in the first instance, they do have these review rights. They can have a go at trying again through the internal review and then again at external review. So becoming a participant and securing funded support, so the 2 key hurdles that people come to us and need help to overcome. Okay, so the first one, becoming a participant. I'll just move on to the next slide. These are the access criteria. So a person needs to be less than 65 years of age. There are residence criteria as well. We see a few people coming through often New Zealand citizens who don't meet the residency requirements. Mostly that third point in relation to access is people either need to meet either the disability or early intervention requirements. The disability requirements are listed in section 24 of the Act, and the early intervention requirements are listed in 25. So that's mostly where people come unstuck, is that they don't meet those requirements. And I've highlighted there further reading the relevant sections of the Act and also the rules. So there's a bit of an overlap between the disability and early intervention requirements. Hopefully this Venn diagram states things simply. The additional early intervention requirement that people need to satisfy is that whatever intervention is provided, whatever support's provided now, is likely to reduce the need for support in the future. So mostly these early intervention requirements are applicable for children with developmental delay who are under 7 years of age. We deal very rarely with cases where people get access via early intervention. It's mostly that it's the disability requirements. The question is about whether a person meets those or not. So the disability requirements are that a person needs an impairment, it needs to be permanent, they need to have a substantially reduced functional capacity, that there's an impact on their ability to participate socially or economically in the community, and that they're likely to need support from the NDIS for their lifetime. So they're the key criteria for access under the disability requirements. I might. Can we skip a slide? I've just realised it might be easier to go ahead to the next one.
We can go back.
So the access criteria are about impact. A person having a substantially reduced functional capacity needs to be in one of these areas. So you don't need to establish you're impacted in all of the areas. It could just be, for example, if you've got you can't communicate, you've got a speech disorder, or we've got a client at the moment who's had a tracheostomy and he uses some technology to speak. He has a substantially reduced capacity to communicate. It may be that if you've got, for example, the fellow born with no legs, he's got a substantially reduced functional capacity to mobilise without that assistive technology. So I recommend clients always pick the areas they're most impacted in and just focus on gathering evidence of that impact in those areas. And you don't need to comment on all of them.
Yeah, there's enough evidence to get just from one area.
Then that's all you need. Yeah. So we'll just go back now. So reviewing a decision about a person not meeting the access criteria, typically people satisfy the first criteria, which is that they have an impairment as a result of a disability, physical or mental disability. Then the two kind of challenges most people face are whether that impairment is permanent and whether it causes a substantial reduction in their capacity to undertake activities in one of those areas. So in relation to permanency, the threshold is quite high that people need to demonstrate that there's no known available treatment that will likely remedy their impairment. So in Social Security law, permanency is defined as there being no treatment that will likely remedy the impairment within 2 years. But with the NDIS, it's within your lifetime. So if there's a prospect that someone may have surgery in 3 years' time, once they've lost a certain amount of weight and the operation can happen safely on their back, if they've got severe back pain, they need to lose weight and, you know, then try that surgery before they will get access to the NDIS. So there's been a little bit of commentary on this issue recently in the media, and I've linked. Can people see hyperlinks?
Yeah, they should see hyperlinks. Yeah.
That further reading little note there on that slide is a link to an article about permanency and the need for people to basically exhaust or nearly exhaust all their treatment options before they can get access to the NDIS. And it questions a person's right to say, well, actually, if this surgery is only going to give me a 50% chance of getting fixed, I don't know if I want to risk that, you know, that having that surgery. But that's not enough, and the NDIA will say, well, your condition isn't permanent because there's this potential treatment option that will remedy it. Yeah. So you can understand the NDIA's perspective as well. I can, but it's a challenge for many to get over that permanency criteria. So looking at the table of evidence that is shared as a handout, you know, that you'll see that in the left-hand column in relation to permanency, it should be expanded upon to say, you know, what evidence does a person have of what treatment options they've explored already, and what future or further treatment is available to them, and will that likely remedy their impairment? Basically, they need reports from specialists to comment on what the treatment options are and what the impact of that treatment will be. And without that kind of report from a specialist, you're not going to satisfy the permanency criteria. So the next criteria that can be problematic for people is demonstrating that they're impacted to a substantial extent. So they have a substantial reduction in functional capacity. Statements from participants themselves are often helpful. Statements from their primary carers, their partners, their children, about how they're impacted, to paint the picture of the impact on a day-to-day basis is helpful, but normally the NDIA won't accept just that evidence. They'll also want evidence from typically occupational therapists who they pay to do assessments, functional assessments, and report on the person's functional capacity to mobilise, communicate, learn, undertake activities of self-care. So that's showering, toileting, feeding yourself. And self-management is more about decision-making, so planning and making decisions about, you know, anything a person needs to within their lives. Yeah. I'm just trying to just talk about, how are we going for time?
It's 10:37.
Okay.
That's 20 minutes.
Okay. There are some examples of permanency. Like there's a case, McFarlane and the National Disability Insurance Agency. This fellow, he had chronic fatigue syndrome and fibromyalgia, which is generalised pain. The tribunal decided they couldn't say that chronic pain syndrome was permanent because the evidence suggested that Mr. McFarlane hadn't explored all the options. There was some incidental GP report where the GP had said, oh, maybe some multidisciplinary team approach might help. So I just wanted to point out that case, and just to be aware that if there's anything in the evidence that suggests that other treatments are out there and haven't been exhausted or explored or considered or tried, that will go against a person getting access. Okay, so we can skip ahead to the next hurdle, which is once you've got access, if you overcome that initial hurdle and you meet the access criteria, then it's about getting the help that you need as a participant in the NDIS. So the NDIA will fund what is reasonable and necessary for someone. And so Section 34 of the Act explains what is reasonable and necessary in quite a lot of detail, and the rules expand on those criteria even more. So the criteria are on the next slide. So each support someone wants, so for example, if someone wants 3 hours of a support worker's time per day to help them in their home or to access the community, they can't, you know, prepare meals, they can't feed themselves without a support worker, they'll need to say that that support worker, that time will help that person pursue their goals. So the goal and the plan needs to be about obviously being as independent as possible or accessing the community. Then that support, will it help achieve that goal? Will it help them participate socially? Yes. Does it represent value for money? So there, the NDIA will look at what are the alternatives, and there's not many alternatives for that. But in terms of equipment or modifications to a home or a car, they'll weigh up all the options. That's a big stumbling block for people, value for money. It needs to be effective and beneficial. That's perhaps where something maybe is not regarded as good practice. So for example, with a vehicle modifications case I've got going at the moment, it concerns a young boy with severe disability who will need to travel when he's unwell in his wheelchair strapped into the vehicle. And that's not best practice. That should be done as little as possible, and people should be transferred into seats where possible. So the NDI had questioned, is it right for him to be travelling? You know, is this vehicle modification effective and beneficial with regard to the relevant standards for vehicle modifications? What's reasonable for families and others to do? So a support will only be funded if it's beyond what's reasonable for others to be doing in any event. So it's reasonable that a partner or a relative who lives with a participant does a little bit, you know, to help them. But if they're doing more than is reasonable, if they're up all night, every night, providing support to the person, and then they're going to work, that's beyond what's reasonable to expect a family member to do informally, and the participant ought to be able to get formal support in addition. And then what's most appropriately funded through the NDIS. So there are some rules about what different systems are, you know, will fund and not fund. So often it's health versus the NDIA, or the justice system versus the NDIA, or child protection system versus the NDIA. Who pays for what? So for example, a child who's a subject of a child protection order, you know, who pays for their accommodation or their respite accommodation when that child also has a disability. So that's explained more in the rules as well. So they're the reasonable necessary support criteria. So we'll just go into a little bit more detail. I'm aware of time and that I want to have some time to answer questions. So reviewing this type of decision, I've said here most commonly a support will be refused if there's insufficient evidence. So often the NDI won't say, we don't think this, you know, represents value for money. They'll say there's insufficient evidence, you know, to demonstrate that it represents value for money, or that it's solely and directly related to a person's disability, or it's beyond what's reasonable to expect of others to be doing. So my little points in light blue are there in terms of what evidence you need. So in relation to value for money, I'll just give an example quickly. I had a lady who has a vision impairment and was wanting funding for an ORCAM, which is a device you clip onto your spectacles, and it will read words for you and recognise faces and like that kind of thing. She has a assistance dog, and there's an app on the iPhone that's free. It does the same thing. If you take a photo, it will read the text in the photo. And she was saying to me, oh, but it doesn't look, you know, good. I don't want to use my phone. I want this thing that's on the glasses that, you know, is better. But is it better to the tune of $7 grand, which is what it costs? So is it worth that? So you've got to put yourself in the shoes of the NDIA and do that cost benefit analysis. And we worked out that it wasn't just the looks of the phone and needing, you know, to take photos and the inconvenience of that, the free app. What was also a problem for this participant was that she had her, if she's out at the shop, she's got a dog in one hand, a bag in the other. She's got to let both of those things go to use the two hand-operated phone app. So we could say that actually the benefit of the ORCAM that was $7,000 was there. It was worth the cost because she couldn't practically use the free app, to be honest. So that's, you know, you have to go into that detail to get these supports funded. So that's just an example of value for money. What's reasonable for families to provide? There's quite a lot of cases about this, but often it's the cases concern children with disability, with severe impairments, where the parents are providing 24/7 support, and really it's beyond reasonable for them to be doing that when the children require a lot more care because of their disability than their peers. Solely and directly related to a person's impairment. So there are a number of supports that could be considered daily living, you know, regular things. So for example, there was a gym membership case, and the NDIA said, look, gym membership, that's a normal daily living expense. People pay for that themselves. Why should the NDIA pay for that for this particular participant? And that particular participant could say, well, I need to go to the gym because of my disability, because of my muscle atrophy or whatever it is that I have. And the tribunal rightly determined this case to say that yes, that's true. A gym membership is actually discretionary for lots of people, but if you've got a certain type of disability, it's, you know, necessary.
Mandatory.
Yeah. So there's lots of those matters that we've run. For example, iPads. My children don't have iPads, but I assisted a young girl with Down syndrome to get an iPad because it's a communication device. It's not a regular daily, you know, living expense. It's not, it was solely related, solely and directly related to her disability that she needed that iPad.
Yeah.
We've also run another case that's yet to be published, the decision, or yet to be reported, for a man with multiple sclerosis in North Queensland in relation to air conditioning, because he can't regulate his temperature very well. So again,
in North Queensland.
North Queensland. So the NDIA have said, well, look, this is something everybody just pays for themselves. And they're saying, well, no, he actually needs it everywhere in his home because of his MS. So they're interesting cases, I think, that we've run.
Yeah, very interesting.
And that comes up quite a lot. So you need to point to the specific regular, you know, what may be perceived as a regular daily living expense. Say, no, I need this solely and directly because of my disability. Okay.
Right.
This is just an extra little bit of info because the NDIA can get confused in response to the internal review requests that someone may lodge when they're already a participant and they want different supports. They're not happy with their plan, they request internal review that we've discussed. If after the plan's been issued and that 3-month period has passed, that a person can ask for an internal review, the only other option is for people to ask for an unscheduled plan review. So that's before the time that's set in the plan. In the plan, it will be written, this is due to be reviewed in October, you know, 2019. If things change, obviously things can change from time to time. A person can ask for an unscheduled plan review, but they'll need evidence that their circumstances have changed.
Yeah, okay.
So, for example, I have a client who is a young child. I'm dealing with his mum. His dad has MS and is just being put into some sort of support home, out of the home, so the dad's capacity to help is now decreased. So that's a circumstance, you know, change that I think warrants an increase in supports for this young boy. So there's always that option to ask for a review earlier than the scheduled date. The problem is the review rights beyond the internal review once the NDIA looks at it. So they can, got the 3 outcomes there, they can refuse to conduct the review. You can seek a review of that decision to refuse to conduct a review. But I only recommend you do that if you've got really strong evidence that circumstances have changed. Yeah. And then if that proceeds to the tribunal only has power to tell the NDIA, you need to do that review. So the tribunal doesn't have power to say what supports should be funded. And the other outcomes are that the NDIA may conduct the review and you may not be happy with the outcome of it, but that's where things really end. The review rights are quite limited. So I just wanted to put that in at the end. And just wrapping things up, I suppose, it can be a battle for many. It can be a battle to get access in the first place. And then it's not that uncommon that I then see the clients I've helped to get access coming back with reviews of decisions in the AAT about the supports that are being funded by the NDIA. Looking at the decisions that need to be made, looking at those criteria that are listed in the tables that I've shared, and also on these slides about the access criteria, about what are the reasonable necessary support criteria, looking at that from the perspective of the decision maker, and what evidence is there that they can say, yes, look, here's the evidence, I can tick that, you know, put a tick against that criteria. the most helpful kind of advice I can give is that that's the way to approach these cases, because they are bound by the law. They're bound by what is said in the Act and what is said in the rules. And if you set out that evidence clearly, it's more likely that a case will settle sooner rather than later, and you won't need to come to me for help. But it's still welcome. You're welcome to. You're welcome to. So that's it from me. The help that I can provide and that my colleagues can provide. So I'm part-time, and I have some colleagues who also do it, a day here or there. So really between us all, we're probably the equivalent of one full-time lawyer. So we don't have a huge capacity to help, but we're always very happy to receive requests for help, and we'll do what we can in response. So we can help with internal reviews and external reviews in the AAT. My concern is that the people we're most frequently seeing are those who've been able to navigate those review processes that are quite tricky and get through to the tribunal. So everybody else who's not finding the access form in the first place and not getting through, they're not getting help from us, and that is a concern to us that we want to.
You don't know what you don't know. Who you're not helping.
So I suspect it's just the tip of the iceberg.
Yeah. So the more of you that are aware of these processes, the better.
Yeah. And then you can also refer to disability advocates. So there are advocacy agencies. I've listed just a few on this slide, but there are more now in Queensland who are also funded to help with these processes, and they know as much as me really about all of this as well.
Great.
That's about it.
Oh, we're going to do our quiz. Just quickly, if you've been listening, before we get into the questions. So stay on for some questions. We've got 10 minutes, I believe.
Okay. So we'll do this quickly because I think it's helpful to consolidate everyone's learning. This is based on a client I assisted. So she has extremely low blood pressure, low blood volume, a condition she has which causes dizziness and fainting. Let's call her Janine. She's struggling. She can't leave her home on her own. She's young. She's about 28 years old. She can't leave her home on her own without her parents to help her. She literally walks around the house holding the hallway walls. So she was having trouble getting access to the NDIS. So to become a participant, she must have an impairment that is. So select a couple of words from this slide. So you can pop in the question box if you like your answer. Or you can just think in your mind. But think in your head, what's the answer there? To become a participant, she must have an impairment that is permanent and also causes a substantially reduced functional capacity in her ability to do one or more of those daily activities. So in her case, it was really that she had a substantially reduced functional capacity to mobilise. She couldn't get around within the home, let alone out of the home. She lodges her application, but she's refused access as an NDIS participant. It seems the main problem is the NDIS is not satisfied that her impairment is permanent. In particular, in one of her GP reports, her GP's referred her for more testing by a cardiologist and recommend she try drinking more fluid each day to build up her blood volume. But she tells me she's had the testing and followed the GP's suggestions and they haven't done much to improve her situation. What can she do? She can accept the NDI's refusal to access a scheme, or she can lodge an internal review with the NDIA is the answer. She must do this within 3 months of receiving the decision. She needs to establish that her condition is permanent. What she does is she gets more evidence in the form of a report from her cardiologist who confirms there's nothing further that can be done for Janine. And everything already possible is being done to minimise the symptoms. There's not really a remedy. There's some treatment to help her manage, but there's not treatment to provide a remedy. So finally, she's accepted as a participant. She receives her first plan. It has funds for some occupational therapy and a support worker to help her in the community and a shower chair. But what she really wants is an electric wheelchair and a dishwasher. She discussed this with the planner, who included the supports in the draft plan, but they haven't been approved. The decision maker has concluded that they are not, and the answer is reasonable and necessary. So the NDIS decision maker said, no, look, this electric wheelchair and the dishwasher are not reasonable and necessary. So she asked for an internal review of the decision to approve those supports and not the extras that she was asking for. But the NDIS came back and said, no, we're confirming our decision. We really don't think those things are reasonable and necessary. She already has a manual wheelchair that she can operate, so she doesn't need another chair. It doesn't represent value for money. And also the NDIS explained that the dishwasher is an everyday living item. So Janine's aware from the letter that if she wants to take the matter further, she needs to go to the AAT, and she needs to file her application within 28 days. So she shows up to the advice clinic operated by Legal Aid Queensland and receives advice. It's clear she's going to need to get her evidence together and get help to do this. The lawyer explains that Janine will need evidence of the greater benefit, admittedly at an extra cost, of the electric wheelchair. She can operate this independently and doesn't need support from others to push her around in her manual wheelchair, because she actually tires from doing that. So we get more evidence in that on that point. She also needs evidence to support her contention that a dishwasher is discretionary for others, but it's not for her. She needs it as she can't stand at the kitchen sink and wash up. She can't stand for more than a minute at a time. So we gather that evidence, and then those additional supports can be properly assessed by the NDIA. So a final bonus question here is, during the course of the appointment with the legal aid lawyer, she reveals that what really upset Janine in the process was a letter she received from the NDIA's lawyer. The letter asked Janine's OT to answer some questions and asked the OT to compare Janine to a normal person. We acknowledge that that wasn't right, and that wasn't the best use of wording by the NDIA's lawyer, and we, it made Janine feel like a lesser than normal person. And we suggested that she could lodge a complaint with, and the answer is Australian Human Rights Commission. Okay, thank you for participating in that little quiz.
Thank you very much.
Listening in.
Now there's the phone number if you want to contact Andrea at all. You can write that down. And I see that you're all popping through questions, so we will answer those questions now. So there's the phone number if you need to write it down. And please send us through some more questions if you have any, and we'll just sit here and answer the rest of them for the session. Thanks, guys. Okay. All right.
Should we just read it out? Or?
Yeah, I can read it out. So somebody's asked, or they're making a bit of a comment. They're saying that I have worked with many elderly receiving services from an aged care organisation, and they just aren't happy. Fees overpriced, needs not met properly, and terms and conditions are not suitable for many of them. I am hoping to send them to NDIS and also become a career mentor providing services, if this can help solve these issues.
So this is probably a question about the intersection between aged care and the NDIS. Section 29 in the NDIS Act says when people stop being a participant. And so a person stops being a participant in the NDIS if they access services through aged care. But the first time they do that is after they turn 65. So it would depend on, when you're saying many elderly, I'm assuming they're already over 65 and they're already receiving aged care services, in which case they wouldn't be eligible to be a participant in the NDIS. So that's not good news for them. I don't know if the NDIS would provide better support in any event. But if any of those elderly people you're assisting were receiving care under the Aged Care Act before they turn 65, then they can be entitled to receive both. There's the 65 age cutoff, so it depends. So for example, we've helped a client here who has MS, and because there was no other appropriate facility that he could live in, he got services under the Aged Care Act, even though he's, you know, started when he was 40 or something like that. Because he received that service when he was under 65, he can continue to receive that service but also become an NDIS participant. So it depends on the age that a person started to receive support under the Aged Care Act. I hope that answers the question.
Okay. Another person has asked, is evidence or some aspects of it only required the first time a participant tries to access the NDIS?
Yes, unless a decision is made to review the person's participant status, or the fact that they met the access criteria. That can be reviewed at any time. I don't know how regularly that is, as a matter of course, how regularly that is reviewed, but they may need evidence again to show that yes, they do meet the access criteria. Normally once you get access, you're a participant and that's it, but there is a chance that that person's status as a participant will come under question. Unfortunately, disability advocates have told me whenever a person asks for more support, the NDIA will go back
and review
everything, including whether they should be a participant at all in the first place. So that's just, I don't think a person shouldn't ask for what they want, but their status as a participant may be reviewed.
All right, and somebody else has asked us, can we get access to the webinar after today? And the answer is yes, you can get access to this webinar. It will go up on our Legal Aid Queensland YouTube channel, and it will be in the playlist Webinars for Community Workers. So I'll pop that up there in the next couple of weeks and you'll get access to this recording. Okay, another question. I went to sign up as a service provider and wasn't sure about providing the terms and conditions. I can create my own basic terms and conditions, but should I just pay for the one provided?
This is a question I can't really answer. I can help from the participant's perspective, but not the service provider's perspective. You know, there are employment law questions, insurance questions. It's beyond the scope of my expertise. It's also potentially a conflict because we may help participants who aren't happy with service providers and we tell them about their rights to complain to the National Disability Insurance Agency, Scheme Commissioner as well. So that's not something I know the answer to in any event, probably can't advise on, I'm sorry.
Okay. So another question, what is recommended when a review has been put in and waiting 6 months for a decision? I have made a complaint and followed up with the NDIA without a response.
If you can contact a disability advocate to see if they can help. If you've already done that or you are a disability advocate yourself, contact me.
The phone number was on the screen.
I think that's the best. When reviews have taken that long and there's been no outcome, there are different contacts within the NDIA that seem to change every other week, but I helped someone earlier this week. That was the 10-month example, and they've been promised a plan within a week now. From sending a few, well practiced at sending strongly worded emails.
All right, so someone's also asked, in criteria residence, can you please explain what protected SCV means?
Not very well, because I'm not an immigration lawyer, but it basically is a special category visa, I think is the acronym. And that seems to apply mostly to New Zealand citizens who have come to Australia at a particular key point in time. And I forget the year, it might be, they must have been here maybe by 2001 or something. There was a bilateral agreement reached between Australia and New Zealand that the citizens could access the supports of either country. There may be other people that fall within that protected special category visa category, but you'd need to get advice from an immigration lawyer about that.
Okay. All right, someone's asked, are there any particular considerations when making an NDIS application for consumers with mental health problems? Are there any challenges for advocating for this population?
Not really. It might depend on the mental health issue, but the same advice applies. So the same evidence is needed in terms of a diagnosed disability and impairment. This is about access, perhaps. That impairment causes a substantial reduction in functional capacity. So there's not really any particular special considerations. It's just looking at those criteria and making sure you gather the evidence that demonstrates those criteria are met would be my best tip. I've helped lots of clients with purely, mental health conditions. Often their own statement from the impact themselves, or if they're unable to make their own statement, their partner can make a statement about the help that they need on a day-to-day basis, and that can help as well.
Okay. So someone's asked, children over the age of 6 with ADHD affecting learning.
Is that a separate question to the one below? Or? Sorry.
Yes, I'm not sure.
Oh, okay, yep. So the question, again, it would just come back to those criteria. So that child may get access to the NDIS with the application of the early intervention requirements as opposed to the disability requirements. Although ADHD is likely to be permanent and ongoing, there may be some supports that could be provided early on that will limit or reduce the need for support in the future. So they may satisfy that criteria and get access that way. It doesn't matter what way they get access. Once they're in and they're a participant, and then the Section 34 reasonable and necessary support criteria will be relevant. So I don't know how well I've answered that question for you. I tend to have had clients that haven't just had ADHD, they've had ADHD and level 1 or 2 autism, maybe obsessive compulsive disorder as well. So it's normally a combination of conditions, and together they impact that child, to a certain extent that means that child can become a participant in the scheme. So it depends on the extent of the learning difficulty and also what the school's doing to address that learning difficulty, because it may be that the NDIA would say, well, mostly what support that child needs can be funded by the education department, and it's not something that should be funded by the NDIA. Have some sort of surgery. Sorry. Maybe just scroll up. There was that other one. No. Yeah. This question is, you mentioned an example at the beginning of someone being recommended to have surgery, but the person refuses due to risks. The NDIS insists on surgery. What rights does the person have? None. That's the problem. And that, if you read that article, that explains that issue quite well. I think on that slide I had further reading that really the way the NDIA are interpreting permanency and how the extent a person should go to in terms of treating their impairment. It may change, and there's a bit of kind of movement to question the NDIA's approach, but at the moment that person would need to go back to their specialist to say that the risks outweigh the likely benefit of that surgery, and if they've got some letter like that, that may get them across the line. Okay. Person has rights under human rights. Yes, so you can argue that as well, but I think you'd need evidence to show that the treatment is too risky, and normally a specialist will say these are the potential risks, and they would either recommend the surgery or not.
Okay, someone's asked, for outcome 3, slide 25, lodging a further request for an unscheduled plan review, does there need to be different circumstances or just better evidence of the original change of circumstances?
Better evidence of the original change of circumstances. Yeah, so hopefully that's clear. So if you've asked for a review and the NDIA have said, no, we're not reviewing it, we don't think anything's changed here to warrant us looking at this earlier, you might just need better evidence to say, no, 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 my circumstances really have changed. I really need you to do this review. So it's always going back to the same question that was originally posed.
Yes, okay. So someone's also asked, can you please tell us about what grants of aid are available and what the thresholds are?
Sure. So we can provide advice to anyone who calls and asks for advice. So call that 1300 number and book into an advice clinic. So there's an internal review advice clinic that's done for people at the internal review stage that one of my colleagues does. And then there's the external review clinic that's based at the tribunal that I go to on a Friday. And the tribunal books clients in once they've lodged their appeal in the AAT. And they get to a certain stage, they then get offered an advice with us at Legal Aid. Otherwise, there are grants of aid for full representation, but the criteria are there needs to be merit. There's no means test for these cases at all. But there needs to be a likely wider community benefit. So the cases we run will need to be novel or almost like a test case for us to run them, because otherwise mostly they seem to fall into the category of question of evidence and me providing advice about what evidence is going to help, and that tends to be enough. So we don't need to provide that full representation service unless it's a question that hasn't really been considered before in another case.
So someone is also asking, how is reasonable and necessary measured, and who measures this?
So that was on slide, the reasonable and necessary criteria were on a slide. And so what is reasonable and necessary? And there is a case that has gone into what could be what. So to be reasonable and necessary, support must assist a person to achieve their goals. It must help them to participate socially and or economically. It must represent value for money. It must be effective and beneficial. It must be beyond what's reasonable for families, carers or the community to provide. And it must be most appropriately funded by the NDIS. So those reasonable necessary support criteria are in section 34 of the Act. Who decides whether a support meets those criteria or not? The NDIA in the first instance, and then if a person isn't happy with that decision by the NDIA, it can go then to the tribunal.
Alright, so someone else is asking, is there an ACSI application of the Act regarding the age classification being lower for ACSI people?
That is a specific question I do not know the answer to. I suspect there is a difference, but I can't comment. I'm sorry about that.
Okay, someone else is asking, have you assisted many clients with psychological impairments? And if so, have you experienced any difficulty in establishing those impairments are permanent, no treatment is available?
Yeah, the same advice would apply. I think earlier someone else asked about mental health conditions, that you would need a diagnosis, and a letter about that diagnosis from a psychiatrist and or a treating psychologist, and also likewise comments from the psychiatrist and psychologist about any treatment that's been tried and that hasn't remedied the impairment. So it might be that a person's tried cognitive behaviour therapy and medical intervention, and certain medicines prescribed by their psychiatrist, and that still isn't enough to remedy their psychological condition. It just always comes down to the sufficiency of evidence, and looking at that evidence through the eyes of the decision maker is my best tip there.
Yeah. Okay, so someone else has asked, does the person have the right to refuse treatment based on risk of treatment, e.g. surgery, or religious beliefs, e.g. blood transfusion?
That would be a very interesting case, but if you get that, let us know and we'll run it.
Yes.
The risks, again, you just have to, you'd have to get a specialist to comment on the risks versus the likely chances of the treatment remedying. But in terms of religious belief, or, someone not being, it's against their belief to, for example, accept any blood products, that would be a very interesting case to run.
Yeah, it would be. Create some new law. So someone else has asked, do NDIS service providers, coordinators have an obligation to work with disability sites where adults with disabilities reside?
Have you to work with disabilities? I just don't know what the question is asking specifically. It looks like it may be a service provider related question that I wouldn't know the answer to. Have an obligation. I suppose if supports are funded, so where an adult with a disability is living, if they are entitled to and they're funded to get supports in the home where they're living, the service provider isn't obliged to. They can say no, and that person can. This is a guess, but that person could engage other service providers to provide that support. There is a problem we're seeing where participants with particularly challenging behaviours or really complex needs, they're not getting the help they're funded to receive. So their plan may say that they can get this help, but no service providers are prepared to help them.
Yeah.
So that can be a problem. I don't know if that's what this question is targeted at.
Okay, so someone else has asked, what if the person decides, sorry, is this a question? Someone else has asked, what about the what if treatments, i.e. the agency says you might be able to have a lung transplant in the future, i.e. cystic fibrosis, but meanwhile you live with disability and you may or may not even be eligible for a transplant when it comes to that point?
I would like to think that you would get access and that they would say the condition's permanent. But again, if that kind of issue came up, it would be one that Legal Aid would be interested in running that type of case. The question about what extent a person has to go to with treatment to satisfy the permanency criteria to get access hasn't been fully explored. Yeah, so different cases like this would help establish the limits.
Some precedent, yes. All right, so does the NDIS Act discriminate against clients with D&A use as drug and alcohol use, as that is a dependence issue? Can we help prove there is an ABI due to drug and alcohol use?
It would depend on what reports are available from treating practitioners. So whether there's an acquired brain injury, I'm taking that acronym to mean, because of drug and alcohol dependence, that there'd be no discrimination against those clients. That's, if that was diagnosed, then that person and they met the permanency criteria and they were impacted to a substantial extent, they would get access because of that acquired brain injury.
Okay, that looks like all the questions. Thank you everyone who put in a question. It's great to have so many people interested in this area of law. Before you all leave, I just want to quickly say a few words about our general contact lines. There they are on the screen if you need them. Office locations, we're all throughout Queensland. We've got 13 offices. Headnote is our e-newsletter if you need to keep up to date with our services. There will be a new one coming out in the next month or so. And all our publications are free and you can download them on our website, and you can even get them sent to your agency in a big bulk lot if you order some. Now this webinar will be going up on our YouTube channel, as I said before, and I'll let you know, I'll send you an email when it is available on our YouTube channel. Now there's a short survey that you'll get once I close this webinar, and it would be great if you could fill it out for us, because that lets us know how useful the information was and whether we need to do another NDIS webinar again. Yeah. And our next webinar for Legal Aid Queensland will be on the 12th of September, and it will be around the Human Rights Act. So if you're in Queensland, this will be specifically relevant to Queensland audiences because it's about the new Queensland Human Rights Act. So stay tuned for promotion for that one. I'll send an email around when that one's out. Okay, well, thank you everyone. Thanks for joining. We'll see you next time.